Good morning, everybody, and welcome to Roetzel's webinar on union awareness and avoidance. I'm Tom Wiencek. I'm new to Roetzel, but I'm not new to labor law. I've been doing this for a little over 40 years, and hopefully I can provide you with some insight into this subject, which is one of my favorite subjects, frankly. If you've got questions, please use the Q&A box at the bottom of the screen, and if there's time permitting, I will answer your questions relevant to this presentation at the end of the presentation. We've got a lot to cover, and I know you're busy professionals, so why don't we get started? Why are we here? One of the biggest reasons is that the NLRB has decided several different cases making it much easier for unions to organize. I will get into the application of these cases a little later in the presentation, but I want to highlight them for you now. A very important case is CMEX. That allows for voluntary recognition based on authorization cards without using an election. The other case that's important is American Steel. It reintroduces the union organization of what's called micro units based on a specialty healthcare standard, essentially allows unions to organize slivers of your workforce, even though a larger bargaining unit would be more appropriate because it contains a community of interest. Starbucks, to me, this is one of the most important cases. It lowers what's called the Gissel standard of outrageous and pervasive employer conduct as grounds to impose a bargaining order. So in other words, if you commit an unfair labor practice, either before or during a union election, Starbucks has lowered the standard for the board to decide to order you to bargain with the union and recognize the union. Stericycle. Stericycle increases the scrutiny that the NLRB will impose on personnel policies looking for any kind of chilling effect. This allows the NLRB to essentially play the role of Big Brother, second-guessing your policies and procedures. Amazon. This is a case that was getting a lot of press because it eliminated what's called captive audience speeches. So now you can no longer require employees to attend meetings to discourage union organization. There are certain disclosures and assurances that are needed in order for you to meet with employees, and we'll go over those standards a little later. But the bottom line is that these cases are increasing the risk of management preventing and challenging a union election campaign. And the new laws have the effect of self-censoring HR and company leadership to make organizing activity of your company a lot easier. We also have some political changes that may be meaningful. Lori Chavez de Reamer. She's a proposed Secretary of Labor about to be confirmed. She's the daughter of a Teamster, and she supported what's called the Protecting the Rights to Organize Act, otherwise called the PRO Act, which makes organizing a lot easier for unions. We also have a change in union leadership, much more militant union leadership. This is UAW President Shawn Fain. If you could actually see the shirt he's wearing, it's called Eat the Rich. I call him the Great Divider because he's introducing class warfare into the bargaining table. And during the Big Three negotiations, he refused to shake management hands at the beginning of negotiations, which was a tradition, 75-year tradition. And at the end of the negotiations, and in response to the Ford chairman's statement that the UAW and Ford must work together to compete against foreign competitors, Fain stated that the union and Ford are no longer on the same team. He's introducing an us versus them attitude into the bargaining process, and he's making income equality an organizing and bargaining theme. All of this attitude trickles down to the local unions that will be attempting to organize your company and invade your culture. And this is what happens when you get organized. We stand with the UAW. Instead of standing with the employer, the goal of the union is to make sure that your employees, who you're providing the living for, the paycheck for, stand with the union. And it's also aided by government coercion. In 2024, 33 senators sent threatening letters to 13 non-union car makers, insisting that they be neutral in the face of union organization and implying that $13 billion in federal money earmarked for EV transition could be at stake, trying to leverage union organization. In October of 2024, 70 congressmen signed letters pressuring Stellantis to meet UAW investment pledges to open up other auto facilities, even though the company faced a dramatic drop in car sales. Here's another bad boy. Teamster President Sean O'Brien, who spoke at the Republican convention, not to be outdone by the UAW, he declared that there's a war on workers. This is all rhetoric taken from his presentation. He was introducing a combative attitude in your work culture. And frankly, you can use the war on workers theme against them. I won an election last year by turning around the war on workers they had. That is their national theme. By turning around against them and convincing the employees that this was not something that's part of our culture. We don't have a war on workers. So this kind of hyperbole can be used against the union, but this is something that they use as a national theme. And once again, he said that workers own the nation. Again, it's all about power, and another great divider. All of this, again, trickles down into the local chapters, which is what I experienced in my last union election with the Teamsters, a very aggressive union campaign. Then we have the National Education Association, Becky Pringle. The NEA is the largest union in the country. It's 2.7 million members. Now, there was a convention that they had in 2024, and she made no bones about it. We will organize for power, and the power is going to be exercised over your companies. Another great divider. So the union will brag about their victories, but they never talk about the job and income losses. So in 2021, for example, the UAW struck John Deere and they got 20% raises over 5 years plus an $8,500 bonus in cost of living adjustments. But in 2024, they didn't tell you the story that Deere let go more than 1,800 employees, including a large share of the United Auto Workers members. And then in 2023, UPS had to increase part-time wages by 35% to avoid a Teamster strike. But in 2024, in January, they cut about 12,000 jobs, mostly management to save costs, but they also closed 200 sorting centers and eliminated almost 1,000 jobs in Colorado and Oklahoma in favor of automation. Then, of course, you're probably aware of the union lobbying in California to raise the hourly rate for fast food workers to $20 an hour. But employees found quickly that their hours were reduced as well as their total income as a result. I've never understood why they try to organize the fast food workers. Fast food workers, really, it's a transitional job. It's not a job that contemplates supporting a family of four, but the unions tend to focus on those kinds of industries in order to organize. So let's take a look at a little bit of union cultural hypocrisy. What happens when a union is the boss? Well, even unions don't like unions. There are 300 staffers who worked for the NEA who went on strike last year at the convention in Philadelphia. They hadn't gotten a pay raise in 9 years. The NEA locked them out, which is considered by most unions against management to be a nuclear option. They canceled flights and hotel payments of the strikers. They suspended the employees' pay. They threatened to cancel employees' health insurance. They withheld overtime pay. They contracted out work. Unions act like management when they're unionized. And that's why you should never apologize for not wanting a union or resisting union organization. So what's the goal of today's briefing? It's to understand what unions are and what causes them, and to increase your awareness and identification of union activity and how to deal with it, and also increase your confidence in how to react to union activity by knowing your rights and minimizing confusion to challenge your judgment, because knowledge is indeed power when it comes to union organization campaigns. So what are the takeaways from today's briefing? First and foremost, you don't want a union. It doesn't mean that you are anti-employee, but I will show you that you simply do not want a union. And you don't have to apologize for not wanting a union. You can lawfully state in a non-threatening way to your employees that you prefer to be non-union. You can and should prepare policies and methods to preempt the need for your employees to be interested and vote for a union. And you should know certain areas of the law to be prepared for immediate action. So I'm going to try to help refine your instincts to reduce your doubt in your judgment and don't be exploited because of uncertainty or insecurity. Let's take a look a little bit about the union election process in general. I'll give you an elevator's view. If a union wants an actual formal election, they have to get 30% of those to be organized to sign authorization cards. So if you have 100 employees that they're trying to organize, at least 30 of them must be signing authorization cards to get an election. But here's something that's an important nuance. The majority of those people who vote on election day determine the election. So if you have 100 employees and only 3 of them show up for the election, 2 of them vote for the union, 1 votes against, that's a majority vote, and the entire 100-person bargaining unit is now recognized by the union, and you have an obligation to bargain with the union. So that's essentially how the election process works if you're doing a formal election. But now there's a slow renewal of what they call the Joy Silk Doctrine, where you can get voluntary recognition upon a 50% showing of majority status if the employer can't demonstrate any good faith doubt that the union doesn't represent the majority. There would be no election necessary. And that's why this CMEX construction case is a very important case, because that's introducing again the Joy Silk framework for recognition without an election. And the employer's motivation to object to the recognition has got to be based on good faith doubt of majority status instead of any rejection of collective bargaining principles or to stall time to respond. So you have to have some legitimate reasons to be articulating why you think that an election, a formal election with a petition, is necessary as opposed to voluntary recognition. The UAW and the unions are also setting up links on social media sites, on X, for example, formerly Twitter, that include the online forms to fill out for recognition. So they're using social media to organize employees. And this concept of micro units are back in play under a case called specialty healthcare, where you can organize just a sliver of the employer. So for example, IKEA recently had an election with only 15 technicians, even though it was from a unit of 400 employees that also shared a community of interest with them. And there's a different standard for these micro units. The employer must have to demonstrate that the micro unit has an overwhelming community of interest with the broader unit. That's almost an impossible standard to meet. So typically the union, once it proposes a unit, unless they have people who are clearly not intended to be in a unit like supervisors, typically the board will give the union the bargaining unit that it's proposing. So let's take a little closer look at CMEX to give you some hints about this. Once again, it follows this principle of Joy Silk that permits recognition and certification by a bargaining representative upon request based on signed authorization cards by a majority of employees. But significantly, and I put a star by this, the employer can challenge that majority status or appropriateness of the unit by filing what's called an RM petition. It's a petition that's on the website of the NLRB. So you can file that to demand an election be held. But as the last bullet notes, you have to do it within 14 days of the request for recognition, or you risk voluntary recognition of the union. And I suggest that you don't ask to review the authorization cards, because you may violate the act for refusing to bargain with a union where you have independent knowledge of a majority status. So if they present you with authorization cards, tell them you prefer an election, that their allegation that they represent a majority of the employees is inconsistent with your perception of what the culture is in the unit and the feedback that you've always received from employees, and you question whether or not the unit's appropriate, so go get an RC, what's called an RC petition, and file a petition for an election. And look, if they do file a petition for election, once again, it's called an RC petition, look at it carefully. Make sure that there's a box there that is checked for an actual election, as opposed to being used for voluntary recognition. This is an important nuance because the old general counsel said that an RC petition, which is normally used to try to get an election, can be properly marked and be a demand for voluntary recognition. So watch out for the gotchas on this and look at that petition if it's filed very carefully. And be aware that if a union does file an election petition, an RC petition, then withdraws it, and then turns around and demands voluntary recognition, there's case law that says that a CMEX voluntary recognition should exist if you don't file an RM petition. So in those situations, it's always advisable to file an RM petition unless the RC petition clearly says it's for a union election. Now, if an employer commits a serious unfair labor practice during the processing of an election, the NLRB can issue what's called a GISL bargaining order. So that's a bargaining order that forces the employer to recognize and bargain with the union without an election. And GISL is a U.S. Supreme Court case. And what GISL required is that the kinds of unfair labor practices that would create a bargaining order would be hallmark unfair labor practices of outrageous and pervasive conduct for a bargaining order. But CMEX appears to lower that standard for something more, just above garden variety unfair labor practices could potentially cause the NLRB to order you to recognize and bargain with the union. So that's a significant change. And CMEX will also look at employer conduct before and after a petition is filed. Before CMEX, typically, you looked at the employer's conduct toward the employees after the petition was filed. When a union petition for an election is filed, from the time the petition is filed until the time the election occurs, it's usually between 30 and 40 days, and that's called the critical period. And the NLRB used to really analyze the behavior of the employer during the critical period. Now it does it before and during the critical period. And the NLRB has declared, this is why this is all significant, the NLRB has declared bargaining orders are preferable to rerun elections if serious unfair labor practices have merit. So for example, if the union loses the election, challenges the election, the board could, and the board finds that there were some improprieties and unfair labor practices, it has the right to schedule a new election. But now it's expressing a preference, instead of a rerun election, just to order a bargaining order for the employer to bargain with the union and recognize the union. And the regional directors have been instructed to schedule the elections at the earliest times practical. Typically it's 30 days. But when you get these petitions and you start interacting with the NLRB, they're going to try to get it in 21 days or as soon as possible. So you won't have much time to deal with the union organization campaign once that petition is filed, which is why it's an ongoing process that you should be prepared for beforehand. So what does it mean for you? Culture, cultivation, and maintenance is at a premium. Human resources and lead supervisors, they have to be educated about the law and be on top of their game. Union avoidance campaign is an ongoing HR project. It is not a reaction to a union demand for recognition or a union election petition. So let's talk a little bit about the National Labor Relations Act. This is the federal law that allows employees to organize. Section 7 of the Act is a genie in the bottle. It's one of the most important provisions for employees. It protects employees' concerted activity, and that includes organizing and voting in a union. So Section 7 is what allows your employees to organize a union. But what many people don't realize is Section 7 just doesn't apply to union employees. If you have non-union employees who are covered by the Act, they can engage in what's called Section 7 activities. So if it's too cold on the shop floor and your employees decide to walk off and protest, you can't fire them for that. That's protected, concerted activity. You can replace them, but you can't fire them for that. So Section 7 applies whether your employees are organized or unorganized. If they are covered by the Act, they have the right to engage in mutual protection in concerted activities. So Section 7 is a very powerful provision that protects employees. Section 8A1 will prohibit coercive employer conduct towards employees based on their protected activity, including filing petitions and engaging in an election campaign. Section 8A3 prohibits discrimination regarding terms and conditions of employment to encourage or discourage membership in a labor organization. So that's the discrimination section. Then you have Section 8A4. That prohibits any kind of discharge or discrimination against an employee for filing charges or giving testimony under the Act and participating in the process. And then there's Section 8A5. That's what provides the union and the employees with the right to bargain in good faith. And most importantly, which is not necessarily understood by a lot of people, 8A5 allows the union and the employees to ask for information beyond the personnel file and other files that are required by Ohio law. Most of you probably know that there is an Ohio law that requires essentially name, rank, and serial number information upon demand. Section 8A5 of the National Labor Relations Act provides a much bigger discovery standard on what you can get and what's accessible and how liberal it is to allow a union and employees to ask for information. It is way often too overlooked by management. And as far as I'm concerned, it's one of the main reasons why you don't want a union, because 8A5 gives the union a lot of power to start getting into what I consider to be more private and sensitive information that the employer has about its employees and about its operations. But this is one you should put a big star by. Section 8C of the National Labor Relations Act. This is considered the First Amendment of the National Labor Relations Act. This is what allows employers to express any views, argument, or opinion, or the dissemination thereof, whether it's written, printed, graphic, or in visual form. The kicker is you can't have any threats of reprisal or force or promise of benefit. But 8C is something you should always remember and use that in terms of parlance when you're confronted with either a union or employee, so they know that you know the law. 8C is the First Amendment of the National Labor Relations Act. However, a word of caution, this Starbucks case, which is one of the cases that I think is the most important that came down, that challenges now an employer's Section 8C rights, saying that if you're going to be talking about during your union campaign, if you're going to be talking about the downside of unionization, your predictions must be carefully phrased based on objective fact to convey an employer's belief as to demonstrably probable consequences beyond his control. So this Starbucks case narrows the First Amendment right of Section 8C and allows the board to start second guessing the kinds of comments that you will make in an election campaign where you're trying to encourage the employees not to vote for the union and to support the company. And they do that on a case-by-case basis to keep up the suspense. So the Starbucks case gives the NLRB much wider latitude to second-guess statements in employer campaigns to overturn elections and even potentially issue bargaining orders. That's why I think Starbucks is even more important than the Amazon case. Let's take a look a little bit at the National Labor Relations Board. This is the agency that administers the National Labor Relations Act. This conducts and supervises union elections and unfair labor practices. It's divided into 30 regional offices across the country. Cleveland is Region 8, Cincinnati is Region 9. Congress in 2024 funded it for $299 million, which is a $25 million increase. Typically, you have 5 members who are appointed by the president for 5-year terms. Right now, President Trump removed Gwen Wilcox, who was the chair. He removed her on January 27th of 25, but that's been subject to challenge. But right now, as of this morning, as I checked, there's only 2 members of the board, Marvin Kaplan and David Prouty, and Marvin's term goes up in 2025. So you'll probably see some real activity here in terms of board appointments. Typically, the board majority reflects the administration that is in office in Washington, D.C. So I suspect there will be other Republican-oriented people appointed. But right now, the NLRB is at a stalemate with only two board members. The other part of the process is the general counsel's office. That's all part of the government that deals with the elections and unfair labor practices, but they are independent from the NLRB. They essentially prosecute unfair labor practices, and they're very good at it. They almost got $57 million in back pay because of unfair labor practices in 2024. And most of you probably know that Mr. Trump removed Jennifer Abruzzo on January 27, 2025. She is no longer the general counsel. She's the one who I think made the board go off the rails, or the NLRB go off the rails in terms of adding jurisdiction over non-competes or payback provisions when people are given money up front as bonuses. But now he's appointed temporarily, and I hope permanently, William B. Cohen is now the acting GC. And I can tell you that I've known Mr. Cohen for 20 years. I consider him a friend. He is a very, very sharp guy. He is a man of faith. He is a graduate of Cleveland State University here in Cleveland, and he is a very good person. You could never have a better person for that position who will be fair and reasonable. So I'm looking forward to his administration. But there's been a lot of activity. 21,300 charges were filed in 2024. That's a 7% increase over 2023. And it's the NLRB who decides these cases in a quasi-judicial body through administrative law judges. And they have a 93% win rate in 2024. So you're really fighting an uphill battle with these unfair labor practices. And it's not that these judges are all that good. It's just that they're all one big happy government family. So you're always going to have the field a little bit tilted against you when you go up in these unfair labor practices. So why do unions organize? It's a rhetorical question. Dues is money, and money is power. Unions spent over $2 billion in 2020 and in 2024 election cycles. So they're not a charity. They expect something in return. And they report millions of dollars to be spent on organizing activity. For example, the SEIU spent $81 million in organizing, but only used 12% of the dues for represented services in 2020. UAW, $99 million strategic fund for organizing. AFSCME, $46 million in 2018. Big labor is a political business. That's the reality of it. You can sort of blame Andy Stern of the SEIU, who started the Change to Win and redirected unions' efforts, not necessarily just to organizing employees, but to getting politicians elected and putting money into elections so that you have politicians who can affect the legislation that makes it a lot easier and tilts the playing field. Now, if you are organized, I'm going to give you a tip about a concept called deauthorization. This is a process that is not necessarily advertised as much as decertification. Most of you probably know about decertification. That's where the employees, similar to a regular election, have an election to get rid of the union. They have to have, just like an election, 30%, and then the majority of the people who vote on election day determine whether or not the union is in or out. And the kicker with the decertification election is you can't have the election during the period of a contract because there's a contract bar. The only time you can have a decertification election is toward the end of the contract. There's a 30-day window period, depending on which industry, whether it's a hospital or non-hospital industry. You can do it during that 30-day window period and then after the contract expires. A deauthorization, however, is a petition that can be filed at any time during a contract. There is no contract bar for deauthorization. And what deauthorization does is it nullifies the union security clause, where the employees no longer have to pay dues and they don't get fired if they don't have to pay dues. That can be done at any time during the contract. And the only catch is that when the election occurs, it has to be by the majority of the people who are in the bargaining unit. So if you've got 100 people in your bargaining unit, the majority of those 100 people actually have to vote to deauthorize, as opposed to a certification election where anybody who shows up, the majority of people who show up are the ones who determine whether or not there's a decertification election. The deauthorization has to be the majority of the bargaining unit. And I can tell you, I've done deauthorizations a couple of times. It's very effective because once you nullify the union security clause and the union is no longer getting any money, they either file what's called a disclaimer of interest, or they no longer want to represent the union, or excuse me, the employees, or they become very disinterested, which then leads to a lot easier process to decertify the union. So that's a tip that you can remember if you are unionized. Deauthorization is definitely a powerful tool to consider. So why don't you want a union? The problem is that unions can be more interested in advancing their ideology and political beliefs than reaching agreements. And I can see that more and more. The UAW was very involved in the Middle Eastern protests in support of the students because they're trying to organize the graduate students. So they are now getting into more political issues to advance their agenda instead of just focusing on wages, hours, and terms and conditions of employment. Unions are becoming much more ideological, especially the Service Employees International Union. And they're rarely aligned with your culture. They can dilute and they can contradict your narrative. They typically alienate leadership, supervisors, and human resources from the workforce. You become the enemy. They can be a downward leveling force that benefit the marginal employees, and they create constant issues, many of which cannot be resolved. So, for example, I've never gone to the bargaining table representing hospitals where staffing ratios weren't an issue. It's an occupational hazard. Staffing challenges are an occupational hazard. Class size are an occupational hazard in school districts. Safety issues are always going to be an occupational hazard on the shop floor. And now they're introducing social responsibility and class culture wars. But you go over the same kinds of issues over and over again where they magnify issues that can be managed but not necessarily solved completely. And theoretically, unions deny employees hired after the election the right to have voiced their choice. So once the union gets in and you're into it for 5 years, the employees that you're going to be hiring 5 years from now never had a voice as to whether or not they wanted a union. And that's why I supported Governor DeSantis in terms of what he did in Florida, that after a certain period of time, if there's the support for the union reaches, I think like 60% is not paying union dues, that you have to have a different kind of reconfirmation election. And I think that's a lot fairer, but that's not how the process works right now. Unions tend to focus on the negative aspects of how the employer treats employees, and they magnify small problems. You rarely see a union praising an employer. And they strain and misdirect employer resources. In 2022, there was almost 18,000 unfair labor practices filed. Almost 20,000 unfair labor practices filed in 2023, and over 21,000 unfair labor practices filed in 2024. If you've ever dealt with this, you know that it's an expensive process with interviewing witnesses, putting together the law, putting together a position statement, doing the appeals process, It misdirects employer resources to deal with a lot of unfair labor practices, which many are just harassing unfair labor practices. Union strikes are also up. There's 16 million days of idleness in 2023. Unions also cause inflation. UPS drivers will make $170,000 in pay with 7 weeks vacation, no contributions for benefits by the end of their 5-year contract. And some longshoremen will make over $200,000 a year with overtime. And the longshoreman president is making $900,000 a year in compensation. These kinds of inflationary patterns, they raise expectations and embolden other unions to ratchet up wage and benefit expenses in industries that really can't afford them. And those are ultimately passed on to the public. And there's an interesting book by Peter J. Bergen called Union Proof that outlines that the cost of operating a union employer can be 25% to 35% higher. And unions can reduce the employer's market value by as much as $40,500 per worker. And this is real. I've been involved in situations where there was a money set aside of millions of dollars in case the union organized the employer that was selling a company, simply because buyers know that it's going to cost more money in a union shop. And unions tangle you up with government agencies, OSHA, the Department of Labor. They do it as leverage for concessions or to shame you to build credibility and purpose. And most importantly, once again, under that Section 8A5 provision that I talked to you about, unions can gain lawful access to sensitive employer information. This is key, and it's often too overlooked. And to me, it's the number one reason why you don't want a union. And let's take a look. These are real examples in union negotiations. This is a demand letter that we got from the SEIU. Take a look at it. The union's requesting information. They want it on a spreadsheet, nice and easy for them, in Microsoft Excel, separated value or similar format. They want the names, the addresses, the phone numbers, shift designation, base wage rate, total hours worked, total hours paid, total hours straight time, total hours for overtime. The list goes on. Sick leave hours, total dollars paid for sick leave, total bonus or incentive pay, vacation, personal leave hours, unpaid leave hours, healthcare coverage, retirement benefits. What's the total cost to the employee? What's the total cost to the employer? What's the total cost of the entire benefit? Current starting and wage rate or salary for each job classification. They want copies of all the job descriptions, all the work rules, and list goes on. All the policies related to employment conditions and benefits, current hospital policies and procedure, all relevant documents concerning changes made to the health and pensions. Copies of all summary plan descriptions of the hospital benefit plan, any actuarial analyses of the plan. And in the final paragraph, they say the union may require additional information. And when do they want it? They want it as quickly as possible. And provide the information as it becomes available rather than just waiting and giving it to you and in one package. And they want it via email rather than on paper. So not only are they demanding this kind of extravagant number of demands for information, they want it right now and they want it in a convenient format. This is the kind of thing that you want to avoid and why you don't want a union. And when you have a grievance procedure, which is a normal part of a union contract, once again, you get these kinds of requests and that they will supplement the information if this isn't good enough. But this was, again, it was a patient abuse issue, but they wanted the personnel file, the medical charts, all the staffing sheets, interview notes, police reports, security reports, and then include with the notes the date and time, any phone interviews conducted, all the patient complaints for all the period, all the notes, memoranda between the grievant and among management, copy of the hospital's administrative leave property, and they want it provided as soon as practical, but they will insist that no later than 2 weeks from the date of this letter. Once again, trying to exercise power, trying to create drama, trying to create stress. And then once a petition is filed for an election, the NLRB has the legal authority to request your employees' home addresses, the available personal email addresses, the home and cell phone numbers. So this is the first step in invading and eroding your culture. And there's really an agenda behind these information requests. So when you see picketing and you see ULP strike, there's an agenda behind these burdensome information requests. It's a strike strategy to preserve jobs because unlike economic strikers, you can't permanently replace ULP strikers. And what could be more sympathetic for a ULP than the employer's refusal to provide all the information that would make them effectively be able to represent and negotiate a contract? So that's one of the agendas that they're trying to do, is create an unfair labor practice where if push comes to shove and they go on strike, it'll be a ULP strike and you won't be able to permanently replace the employees. They also want to set up a constructive lockout, because people that go on strike aren't necessarily entitled to unemployment compensation unless it's a constructive lockout. And there's case law that'll support that if it's because of an unfair labor practice, that would be considered a constructive lockout. That's another reason for these kinds of demands. And then, of course, no impasse can be reached if you've got a pending unfair labor practice. So if you wanted to change the benefits and make them less to save money, or make other kinds of cuts that you would want to implement at impasse, you can't do that if there's an unfair labor practice out there. So that's the kind of agenda that's behind, and the games that get played behind these kinds of information requests. But I'm going to remind you, you have the right to ask the union for information also. You can send the union your own little labor law love letter asking them for certain information as to the competitive wages that they're saying that they have with their other contracts, et cetera. You can also demand the same thing from unions as they can demand from you. And these demands aren't necessarily absolute. Your response to the demand can be negotiable. So you can sit down with the union and say, this is a negotiable. This is what we can provide. This is what we can't provide. This is what it's going to cost for us to provide it. So it's going to cost you 10 cents a copy, or it's going to cost you so much for an hour for our people to gather this information. So it's not absolute. But my point in pointing this out to you is that this is the kind of burdensome process that exists once a union gets in and they've got the legal support to do that and to leverage you and get you entangled with administrative agencies. So let's take a look at a union playbook. This is the SEIU campaign manual. All right, as part of their organizing sales pitch, unions like to make employees feel that they're special and unique. But most of these unions have cookie cutter manuals about the organizing process. They just target disgruntled employees with promises. And this is the SEIU campaign manual. I've also got the Teamster playbook. And I've just given you an excerpt here of the handbook. And take a look at it. Escalating pressure tactics, evaluating possible tactics, rallies and demonstrations, outside pressure, legal pressure, political pressure, pressure on individual officials, workers' role in researching pressure, how to work with lawyers, community action, other unions dealing with the same employee, using the media, helping reporters do their job, creating news. This is all part of a cookie cutter opportunity for them when they organize and they're trying to organize your people. So it's all pressure tactics on employers and with customers and vendors. You got worksite activities like war on worker rallies, concerted refusals to work overtime and do certain jobs, and all kinds of pressure and disruption in your supply chain. Sometimes it even goes so far. I was representing a hospital that wanted to expand, and the union purchased real estate next door that was going to be used for the expansion to put pressure on the employer for recognition. And then, of course, newspaper and radio ads, relentless robocalls, picketing and handbilling at board members' places of work and at their home, and publicly embarrassing the employer, including billboard trucks with their pictures, calling them greedy, running around the neighborhood, running around the city trying to embarrass them, and handbills in neighbors' mailboxes. This is all part of a union campaign. It's all part of the process. So what are some of the election trends? They doubled. The election petitions have doubled since 2021, and they're up 27% since 2023. So there's a lot of activity. There's 3,200 RC petitions filed in 2023, and unions won about 83% of those. So the average time to conduct an election is about 38 days, and unions typically have won 50% of those elections in the past 10 years, and 48% of non-union workers stated they would join a union if they could. So the climate right now, and it may change under Trump, but I think Trump in many respects can be considered sort of a rhino when it comes to unions. The atmosphere right now, I think, is ripe for unionizations. And 71% of Americans now approve of labor unions. That's way up from past time. And you have a little change in social profile. It seems, at least based on the research that I've done, that the millennial generation is more susceptible. It seems to be more susceptible to unionization. 69% of younger workers say unions have a positive effect on the country. As a generation, they tend to avoid high-risk behaviors and gravitate towards large institution and government agencies that are ripe for unionization. They seek teamwork, and they especially seek protection against risk in remote work and casual dress. Those are the kinds of new issues that unions are selling to the younger people. They want the work-life balance, and they have a strong sense of belonging. So the millennial generation, at least from what I've read, tends to be more interested in unionization than older generations. So what are the unions saying to the employees? What's the sales pitch? Of course, they're going to say better pay and benefits. The UAW had tremendous success in 2023, and unions were using that as an object lesson. But the real issue that gets employees to organize unions is this issue of dignity, respect, inclusion, and activism. And the way that you can counterbalance that is to draft a mission statement. So when those kinds of issues, when that sales pitch is being made, you can at least have a mission statement to say, we've already done that. That's already part of our culture. Protection from electronic surveillance is also a big issue here with regard to GPS, and now AI is going to be a big issue. The NLRB views it as unlawful surveillance. So I would recommend that you provide, if you don't have a union, provide prior notice and communication to your employees if you're going to be setting something like that up. And the unions are addressing more needs for balance and remote work. And they're going to say that they've got the best conditions in the industry, and they're going to focus on narrowing the pay gap between races and sexes. So the way to avoid that, I mean, you should have a narrow pay gap between races and sexes, but the way to assure that is to perform a pay audit. See exactly who's getting paid what and why, so that when the union starts using that as a tool, you've got something to say, we've already done that. We do that on an annual basis, and these are the facts. Now, this is what's really startling to me. Unions are alleging that they can improve your culture. That is unacceptable. Tesla Workers United, this is what Tesla Workers United said. Our union will further Tesla's principles and objectives, including by helping to serve as the conscience of the organization. An outside union is telling your employees that they're going to help to serve as the conscience of the organization. Unacceptable. Once again, it's about culture control. It's about you taking advantage of your opportunities to communicate with your employees to make sure that they feel comfortable in your culture. When I was representing a Catholic hospital organization, one of the things that I did at the bargaining table, just to remind the SAIU that these are our employees. They may be your bargaining unit members, but these are our employees. As I started every bargaining session with a prayer, and I saw the employees on the other side of the table join in with us as the SAIU people sat there stone-faced, just to remind them, this is our culture. So this is about culture control, and that's what unions are trying to do. The Tesla Workers United helping to serve as the conscience of the organization. That is unacceptable. So one of the campaign subjects, the typical union playbook, focuses on about 8 different arguments. A voice in workplace decisions. That is the number one issue that they will hammer home in an organizational campaign. And that's because the only promise that a union can really keep is to be the voice of the workers. They can promise wages, hours, and better working conditions, but the employer's got to agree to those. But what they can promise and keep is to be a voice in the workplace decisions, and that's why HR and leadership has to be the voice, has to control and support and maintain the culture. And they will talk about guaranteed wages and benefits. You got a contract, it's written, they can't reduce it. Not at will employment, just cause only. That's attractive to employees in terms of not being able to be fired except for just cause. But if you've got good HR practices, if you have good policies, if you're fair, you give people notice, you try to work with them, that shouldn't be an issue. Seniority also is very important. That's what they make sure, that there's no favoritism, that everything is going to be done by seniority. They talk about better retirement plans and benefits. Protection of individual rights was more of a big issue in 2020 with masks and mandatory vaccines, and it still may be an issue if that's something that you have in your industry. And they also talk about having the power over the employer to get a seat at the table, to stick it to the man. I think it's a mistake if you are organized and you are dealing with collective bargaining to allow access to the CEO during bargaining, because it just reinforces the union's power. I think it's good for the CEO as part of the culture to do rounding, to meet with the people on the shop floor, to engage the people on the shop floor. But I recommend that the CEO be part of the bargaining process, maybe until the end, when the handshakes should be given and everybody feels good about what they've just accomplished, hopefully. And here's a classic example of union activism in healthcare. This is what the SEIU and some of the healthcare unions were creating. They would create these documents where they were objecting to their assignments because they were short-staffed, and they were keeping tabs on when they were doing assignments over objections, which would be Exhibit A for a medical malpractice lawyer in terms of medical malpractice. But these are the kinds of things that they were doing in order to combat the staffing issues which healthcare industries have to deal with as an occupational hazard. Staffing is always an issue. It's always flexible. You can never predict when somebody's going to get sick or needs emergency care. So, why do the employees join unions? Number one is for voice, recognition and respect, job security, fairness, protection of individual rights, good pay and benefits, and then the right to strike and bargain, which is last. So the conclusion is that the motivation really for employees to join a union is driven more by the culture in the workplace than by money. Now, in inflationary times like we have now, money can still be an issue. But in my experience over the last 40 years, the primary motivation that I've always seen is driven by the culture in the workplace, the voice, the recognition and respect, and how you treat your employees. Do you treat them like human beings, or do you treat them like commodities that can be easily replaced? So let's take a look at some of these conditions that cause union organization. a lack of continuing courtesy and respect, just fair consideration from the managers and supervisors, a failure to respond to their questions and problems in a timely manner, failure to listen and understand the employees before you make a decision and not make it look like a knee-jerk reaction and that their concerns are really being disregarded and you're just paying them lip service, because that's why they need a representative if they don't feel comfortable that their needs are being addressed. An absence of an effective problem-solving procedures. I always recommend that employers, whether it's a suggestion box, have some kind of method for employees to provide input if they've got some complaints or concerns. The absence of an effective employee communication program. I can't underscore more how important it is, in my view, to have a newsletter, whether it's quarterly, biannually. You have to control the narrative. You have to engage your employees and let them feel that they are part of the organization. And one of my clients we had what's called a take the mystery out that we used at the bargaining table. And before the union people got home, they got in their cars, and the people who were at the bargaining table, before they got home, we had a newsletter that was out to everybody saying what went on and what was accomplished during those negotiations. We control the narrative. And what you do is, with a newsletter, by controlling the narrative, when the union comes in, the employees are still looking for you for the information as opposed to the union. So a newsletter, I think, is a very important part of trying to manage not being organized by a union. Making vague promises that are subject to misinterpretation or are not kept. That's always a problem. Obviously, unfair favoritism of employees based on politics or relationships is always going to be a driver, as well as unqualified or undesirable applicants. Keeping people too long who aren't simply holding their weight. And lack of attention to employee facilities. I can't tell you how important that is. It's the broken window theory that was used by Rudy Giuliani before he went off the rails. He was actually a very effective, in my view, he was actually a very effective mayor. Why? Because he fixed the windows. He got rid of the graffiti. He created the perception that we understand. We are paying attention. We're taking care of business. So making sure that your lavatories, your eating areas, your parking is all clean and first class lets employees know that you care and that you pay attention. That's even more important. Can't underscore that more. Lack of attention to maintenance and supplies. Maintenance people drive the culture, especially if you're producing something, making sure that if the machine breaks down, you've got somebody that'll come right in, especially if they're on piecework or they're going to be losing real money, making sure that they have some confidence that if something breaks down, it's going to get fixed. It's not going to interrupt your day. Just think of your own IT support. When your computer's not working, how much stress that is. But if you've got an effective IT people supporting you to take care of it right away, you can continue to do your job. I can't underscore enough how the maintenance people drive the culture. And I represented a classmate of mine in college who was he's a very successful person who had a union organization drive in Michigan. And he would make sure that the people, he was a manufacturer, he would make sure that his maintenance people were the best in the business, because if something broke down, it was fixed right away. That was a culture that did not get organized. And lack of attention to what the competition pays. Always be aware of what the competition pays. Get involved in the organization, whether local or otherwise, to have your hand on the pulse of what the competition pays. And analyze that there's no significant disparity. This is an issue that I've seen lately that's been a motivator for organization. That there's not a significant wage disparity between the starting wage and employees with more seniority. And be careful and sensitive what happens when you credit prior experience, because sometimes you have people that have been there for 5 or 10 years making a certain amount of money, and you hire someone off the street who's got a lot of experience, and instead of giving them the starting wage, you're paying them the same wage as the person with 10 years. That was a driver in one of the organization campaigns that I had to deal with. So that's something to be sensitive to make sure you're communicating to people. If someone's not going to be getting that starting wage and you're going to be crediting them for other kinds of relevant experience, that at least your employees know why. And failure to persuade employees that wage and benefit terms are fair and competitive. Do your own internal PR campaign to reinforce that they've got a good thing. Give them a sense of security. And I think a lack of social activities could be a problem. You know, try to, if you can do a baseball team, a bowling league, or something that creates a culture and a sense of belonging where people do things together, even if it's a potluck dinner once a quarter, to do something that, or watching the Super Bowl together, anything that would promote and create a culture of a sense of belonging. So let's talk a little bit about some managerial steps in preserving your non-union status. One of the things that I've seen is that you should have a careful selection of employee referral agencies. A lot of these agencies don't screen employees well enough, and they invite what's called SALTs, employees who are specifically in these agencies, to get employed somewhere else for the sole purpose of just organizing a union at the company. So be very careful in the selection of referral agencies to see who you're dealing with. And carefully screen the applicants. Take a look at whether people are joiners who find safety in the herd, whether they're opposed to merit. Those are questions you can ask during an interview as to whether they're opposed to merit as a basis of raises. See if they're reluctant to lead or assume responsibility, whether they're followers and might be vulnerable to that kind of activity. Obviously, their past employment will give you an idea if they come from a unionized environment or whether they have members in their family, or people who resolve problems through processes instead of doing it on a one-on-one basis. And of course, SALTs. I'll go over SALTs in a little bit more detail later on, but SALTs are people who are specifically hired to organize the union in your workforce. And this goes without saying, but I see it happening time and time again. Hire and assign supervisors who are social, empathetic, and good listeners, not just good technicians. Time and time again, I see companies promoting people just because they're good at their job. They may have the worst people skills in the world, but they're good at their job. Some of the best coaches we've probably seen in our lifetimes have been bench sitters at times. So it's very important that the supervisor not just be a good technician, but somebody who is social and empathetic and a good listener. And open the line of communication before the union appears. The worst thing you can do is when a union petition is filed and you've never engaged the employees before, now all of a sudden the union's petition gets your attention. That just gives the union a selling tool, saying, hey, they never paid attention to you now since we filed this petition. Just wait until we can organize you. Because there's a difference between pre and post petition election activity. At least there used to be. The law now is actually looking at a little bit of pre-petition activity. But the election petition, once again, is filed. It's called the critical period. Normally, the conduct is reviewed between the time the petition is filed and the time the election occurred. That's when it's more scrutinized. But CMEX and Starbucks are setting the stage for bargaining orders based on conduct before and during the election. I suggest coaching by walking around. You can't beat rounding. Walmart is not unionized for a reason. They have a culture of engaging their employees constantly and asking for input. So the shop floor is a natural environment for rounding. It's important to establish a culture of employee input. So when you have discussions about employees about concerns during the critical period after a petition is filed, it's normal. It's not viewed as potential motivation by the union election. It's just part of our culture. We round all the time. We're always asking our employees for input. Our supervisors and the CEO is always on the shop floor, taking a look at what's going on and getting their input. If you can establish the coaching by walking around and that kind of culture, it gives you much more leverage to have an effective management response to union activity, because even if the NLRB scrutinizes it, it's something that's just part of your culture. Engaging your employees on a one-on-one basis and talking about improvements and concerns is just something that's part of your culture, and it was not motivated by the petition for an election. So this is a very important thing to do. Let's take a look at some proactive labor relations that you can do. The proactive audit. Take a look at your key personnel policies. All right, the usual bargaining topics: overtime, leaves and vacation, promotions, transfers, vacancy, staffing. Look at all the kinds of things that would likely be in a union contract in your industry, and see if you can mirror that in your policies and procedures. And I've given you some information here. You can get a copy of the union contract in your industry. The Labor Management Relations Act requires the Bureau of Labor Statistics and the Department of Labor to maintain copies of available labor contracts. And you can contact them at that number or at that email address. And Cornell University is also a good source in order to get the contract. So what you would do is you would try as much as possible to align your policies to a union contract in your industry if possible. That helps you run a positive election campaign. The worst thing you can ever do if a union is trying to organize your facility is to do nothing but bash the union and run a negative campaign. The most powerful thing you can do is to have a handout that says, this is what this union's contracts look like in other industries, da 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 da. This is what our policies and procedures are. They're the same. They're almost mirror identical of each other, and yet you don't have to pay union dues. So what are you getting for in this union organization campaign? That is a very powerful way to combat the union organization campaign, by showing that employees don't need a union contract. The policies and procedures that you have give them the benefits and protections that they would otherwise get in a union contract. And take a look, once again, employee satisfaction surveys on a regular basis, I think, is a smart thing to do, because it helps you keep control and input to your culture. And I would suggest that you consider shortening times for employees to get top pay and to vest benefits. That apparently is a driver that I've had in at least the last 10 years. That was one of the drivers that promoted the unionization. And once again, the accelerated wage credit for new hires for their experience. Make sure that people know why other people are getting paid the same as they are, even though they've been there for 5 or 10 years, so that they know the reasons for that kind of credit. And I would suggest, if you can, this may not be easy, but you can integrate jobs to establish a closer community of interest, where you can say that these micro units are inappropriate because, yes, these jobs and classifications are so intertwined in what they do that they share an overwhelming community of interest, and therefore you can't just organize a sliver of these employees. You have to organize both the maintenance and production employees, because they have such a close relationship to each other. It's not just a sliver of the 5 maintenance people. So I think integrating jobs is a good idea if you can do so. And obviously the job descriptions are something you handle when you do that. But in reality, the board's not just going to look at the job description. They're going to look at the actual duties of the job and what's being done. This is going to be a little bit difficult, but you might want to take a look at the difference in percentage between the top company executives and the rank and file employees. And the only reason I say this is because I've seen unions use their campaign that, the CEO makes 300% more than the people on the shop floor. So maybe you should consider structuring a bonus formula for executives with a lower salary that undercuts what they would do in terms of trying to make that argument. And don't overlook an assessment of the administration of benefits. You may have some good benefits, but if it takes people hours to get input, if it's very difficult to get certain kinds of doctors, or hospitals are not in the network, etc., take a look at the administration of your benefits and see whether or not that creates any frustration points. And I recommend an annual evaluation of compensation to keep up with inflation. It'd be a COLA in disguise. So you can, once again, in your union campaign, you can say, look, we do this on an annual basis. We take a look at what the market is and we react accordingly. And once again, employee evaluation programs and techniques. How are employees' performance evaluated? Is it fair? Are we using the right kinds of benchmarks to evaluate whether or not they're productive and deserve more increases? Take a look at your disciplinary procedures. Is there excessive turnover based on policy violations? Are you really, do you have a culture where people don't feel they're getting cut any slack? Are you giving them any kinds of second chances? Take a look if you're seeing too much excessive turnover and why that is, and the judgment of your HR people that they're maybe reading the policies a little bit too closely. And once again, take a look at stress points like adequate supplies. And here's an idea that I've seen in some companies, and it may not necessarily be relevant for every company, but a peer reveals process, I think, can be a very important tool. I actually won a federal lawsuit because of a peer review process where the hospital had multiple different locations and they took people from those locations, management and rank and file employees, they put together a committee. And if somebody was going to be terminated, that committee would review whether that termination was fair. Now, you take some chances with that, but that really gives employees a sense of security. And it will give you some input about the culture as you get some input as to what they think is a sense of fairness. It helped me because the woman who got fired said that she got the bum's rush and was never able to tell her story to HR, that all they did was make a knee-jerk reaction and fire her. Well, we had a peer review process and she didn't raise any of the same issues that she said she was prohibited from raising at the HR level. And the judge found that persuasive, that wasn't something that we did, and that she was terminated for legitimate business reasons instead of her race. So the peer review process can be very effective. But once again, it's not for every culture, but I would consider it if you think that you've got people that will give you some sensible reviews. I'm in big favor of obviously doing what you're doing now, supervisory, managerial, but most importantly, security officer training. Your security officers are the gatekeepers. They're the ones that are out in the parking lots. They're the ones that are out in the hallways. So they're the ones, if they know how to identify union activity, they can give you a heads up that there's some issues here. And I think military background is a plus. Most military people are not really inclined, in my experience anyway, to want to join a union. They're very independent, self-reliant people. And if you're an HR person, I would do a boundary assessment. I call it HR teeth flossing because it's something we should all do, but we don't do it as much as we should. But I got a call one day from an HR person saying, I've got all these war on worker signs, that are in front of our property. I'm going to be calling the sheriff's office. And I said, well, where's your property at? And she didn't know. So if you know your property boundaries, you can call the sheriff. You can go out there and tell the union that they're trespassing with a lot more confidence. So I do think that a property boundary assessment is something you should know the contours of your own property. And if you really want to go one step further, a local ordinance assessment regarding picketing and handbilling and public gatherings and noise restrictions and personal home mailboxes can be very effective to know what your local ordinance is like. I dealt with the SCIU in one campaign in Cincinnati where we found out that they were putting flyers in people's mailboxes and flyers in people's front doors, bashing the hospital. Well, there was a local ordinance in Cincinnati that says you can't go on somebody's property and solicit and put something in their mailbox or in their front door without their permission. So we did a cease and desist letter based on that. But we knew what the local ordinance was because we did the research, and that was powerful, and that stopped that aspect of the campaign. So once again, these things are extra cherries on top. But if you can do them and you can show them that you're on top of your game, you know the law, you know the rights, that's intimidating for a union. That makes them pause. that makes them know that you're not an easy target. Social activity, once again, softball, bowling, fishing expeditions, something to get people together with both supervision and rank and file people to enhance your culture. There's a book called Bowling Alone. It's a good book about all that. I'm going to warn you if you ever want to read it. It's kind of thick. It's all about empirical data about how America has just become more individualized and no longer is into community networks, and how things like the Boy Scouts and even the Elks clubs are breaking down, and that's undermining our fabric. It makes a very good point about how these kinds of social activities can really help you strengthen the fabric of your culture. And I'm big on hats, t-shirts, windbreakers, uniforms. Those are things that people can wear with great pride in representing your company, because if you don't have that, then the union will. The Teamsters and the SEIU have some pretty handsome jackets that they'll be giving out to the employees. But if they already have something nice with your logo on it, they won't need it. Now, here's something that I think is really erudite. Depends on what your culture is. I like it and I recommend it to my clients. A union-free philosophy, okay? You can't control your culture without telling what you want your culture to be. But I underscore it has to be a philosophy instead of a policy. Because a policy contemplates enforcement of a condition of employment, whereas a philosophy is aspirational and doesn't apply accountability. That's the big difference. So a union-free philosophy, I would recommend a euphemistic term like an open door philosophy that states the employer favors direct communication with employees without third-party interference. You don't have to mention the word union. But once again, you have to beware of this stericycle case as to whether these kinds of policies and philosophies would have a chilling effect on employees. The board has not applied that to a philosophy, and I frankly don't think it would, simply because a philosophy, you don't put it in your handbook, you don't put it in your employment application, you don't put it in anything where the employee has to sign and commit, and it's viewed as a term and condition of employment. It's just a separate philosophy that you have that you would rather be an open door policy. So I would avoid any specific word of a union in the philosophy, and you can use references like third party or outside organizations. So I'm big on the philosophy, because I think if you're going to lead, if you're going to influence and maintain your culture, you got to let your employees know what you want your culture to be, and having a philosophy that tells them we don't need outside people to tell us how to run our business or how to deal with our relationship. We can do that ourselves. I think that's a good thing. It's going to take a unique employer to be able to be brave enough to do something like that. So once again, do not include, if you go this direction, do not include the philosophy in a handbook or any other item an employee has to sign as a condition of employment. And obviously, this is something, if you go that direction, make sure it's reviewed by counsel. All right, let's take some time now to go over some of the early warning signs of union activity. Be aware of unexplained change, okay? The nature of employee complaints starts changing and the frequency is increasing. Employees are forming in groups that they normally don't associate with each other. Check out the smoking circles. Now, I don't say that tongue in cheek. I had an organization campaign where the smoking circles were a treasure trove of information of who was for and against the union. These people talked between drags on their cigarettes. Smoking circles cannot be underestimated. If there's a large number of policy inquiries all of a sudden, particularly on pay and benefits and discipline, talk about what other unionized companies pay, or you got employees in areas that they normally don't visit, and they're starting now to avoid supervisors. They're clamming up. Those are all the signs and triggers that you might have some kind of union activity percolating. You've got news items placed on bulletin boards about union settlements in other companies. You know, humorous cartoon or graffiti in hostility towards the organization or management and supervision. That's a real barometer of a potential union activity. Strangers start appearing and lingering on the work at your premises or your work areas. And here's one. Employees are starting to adopt a new technical vocabulary, okay, like protected concerted activity and unfair labor practices. Employees normally don't talk like that. When they start talking like that, that means they're meeting with somebody that's telling them about their rights and it's part of an organization campaign. And of course, the biggest sign is union authorization cards, where employees have executed, if you find that employees are executing union authorization cards that call for an election. If you see a union organization card, that's a 911 to immediate action. That means that the union's got commitments, that they've got signatures, and that a petition for an election is imminent. But take a look at all the personal information on this thing that's requested. And one of the things that's conspicuously absent on these cards is the absence of any language about authorization for an election. All right, I choose the SEIU to represent me in collective bargaining with my employer, so they can use this as voluntary recognition. There's nothing there about an election. The sales pitch may be, hey, sign this card and we'll just get an election. It's not a big deal. But that card allows them to demand voluntary recognition. Same with this one, another one. There's nothing in this. The National Nurses Association, nothing in this about an election. Represent me in collective bargaining. I want to attend the meeting, sure. Doesn't say anything about deciding whether we want an election and the pros and cons of unionization. This is a representation card. So once they start signing these cards, you've got an issue. And that's a 911 call to your counsel. So what's your response when you see these authorization cards? You can suggest that employees not sign the cards before getting all the facts. That's lawful. You can point out all the personal and private information the union wants from the employees and how it's intruding on your privacy. You can underscore the legal commitment that's involved in signing a card. It's not like signing a magazine subscription. You're signing an authorization card, and this election, if the union wins this election, they're going to represent you forever. And you can advise the employees that they can return the cards to the union if they change their minds, even if they sign the cards. Now, that doesn't mean that an election's not going to be held. But if enough cards are returned to the union, it may withdraw its petition. Because if the union loses the election, they can't come back and have another election, and no other union can have an election within a year from the date of the election. But if they withdraw their support, if they withdraw their petition for an election before the election occurs, they can come back in 6 months. So a union may decide to do that, and that gives you 6 more months to engage in your union campaign. So you've got certain rights during this kind of campaign. You've got the right at times to express your views, but it has to be based on facts, opinion, and experience. So you can have individual voluntary conversations. I'm underscoring voluntary conversations because of the change in the law. You don't want to be tagged with saying that it was a captive audience speech, even if it's just with one person. So you can inform your employees that you're against the union. You can encourage them to vote against it. Now, this Amazon case eliminated captive audience speeches where you were requiring everybody, subject to discipline, if they don't show up to this meeting, for you to talk about why you don't think that the union is good for your company. So there's a change in that. You can't do that anymore unilaterally. So if you're going to have what's called a captive audience speech, there are several factors that are required. Number one, you got to announce the purpose of the meeting is to address unionization. You've got to say that it's voluntary with reassurances that no one's going to be disciplined for failing to attend or leaving early. And then you have to provide assurances that no records of attendance or early departure will be recorded. So that is a must if you're going to address your employees about why you don't think that they should be voting for a union. Now, I personally don't think this is a bad case. Simply because if nobody shows up to the meeting after you've notified them about what the subject is, then you know you're in hot water. Then you know that you got to start ramping up. You got to start ramping up your campaign. The people who do show up to the meeting are probably going to be pro-management. The people that don't show up are probably going to be against management. So then you can start using that as part of your data. It may not necessarily always be accurate, but you can use that as part of your data to start looking at where the votes are. So you can start focusing your campaign accordingly. So I don't see the Amazon case as being nearly as bad as some of the other management people that I've talked to. And of course, don't ask to talk to employees on one-on-one in your office. That is viewed as coercive. Now, if they come into your office and want to have a chat, that's one thing. But if that happens, I would suggest that you have a witness because you don't want to get baited. Some of these unions will do that. And to hedge their bet in case they lose the election, they can say that there was some coercion there and they have that person sign an affidavit and all of a sudden you're having a rerun election after you've won the election 2-1. So that's my advice to you if that ever happens. When you're dealing with employees about union organizational activity, don't spit on them, all right? That's the acronym to remember. Don't spit. Don't engage in surveillance. Don't make any promises of increased wages or benefits in exchange for the employee voting against the union. Don't interrogate them about their union sympathies, and certainly do not threaten employees. So what does surveillance mean? All right, and it's engaging in conduct that creates the perception that employees' activities are being monitored. I know you were at the meeting last night. I know you support the union. Those are the kinds of things that will get an unfair labor practice. They'll get an objection to the election, and they'll get the election overturned, or maybe even a bargaining order. And at least under the old general counsel in 2022, they're going to more closely scrutinize new workplace technologies such as monitoring and surveillance because they think that that discourages union activity and concerted activity. Once again, if you're going to install something like that, it should be open and conspicuous and have your employees put on notice of that. But just be advised that the NLRB is now wading into this area as to whether or not that's inherently coercive. So you should have, if you're going to do something like that, you should have a legitimate business reason. Now, I've noticed that some of our people out there are in the supermarket industry. That you got very thin margins in that supermarket industry. Somebody's stealing bananas and pears from you. That goes right to your bottom line. So, you would have a compelling reason to do something like that to prevent theft. But you got to have a solid business justification for doing it. All right, promises. What are the promises? Don't promise that something good will happen if the employee doesn't support the union. Okay, we can give you additional pay if the union goes away. We'll have money for bigger raises next year if you don't vote the union in. Those are the kinds of statements that would be unlawful, objectionable, and maybe even grounds for a bargaining order. Interrogation, all right? The intentional or unintentional placing of any employee in a circumstance where the employee believes his activities are being questioned or that he feels compelled to disclose them. What was said at the meeting? Why were you talking to those people? Those are the kinds of things that'll get you in trouble with an unfair labor practice and objection to an election. You just can't do that. Now, they can volunteer it. They can come to you and volunteer it. It's just that you can't be the one engaged in that process. And of course, threats. It's self-obvious. Don't threaten that something bad will happen if the employee supports or votes for the union. And there's direct threat. Layoffs will occur if the union gets in. An implied threat. You'll regret it if you vote for the union. Those are the kinds of things that, once again, they will file an objection to the election. You'll get it overturned, even if you won by a 2-1 margin. So what else can you tell? What else can you tell employees? You can tell them they've got no obligation to vote for the union, even if they signed an authorization card. And again, you can withdraw. You can tell them that they can withdraw their authorization cards by sending them back to the union. That's not going to mean that the election's not going to occur, but it may make them withdraw the petition. And you can tell them the negotiations are a give and take process. You can actually lose in negotiations. You've got all these things that you've wanted. on your wish list, well, frankly, we've been working with a stone on our shoe too. We've got a few things that we can go to the table if you want to start talking about formalizing this process. We've got some wish lists too. You can tell employees that. During an economic strike, you can tell them that employees can be permanently replaced and don't receive unemployment compensation benefits or paid insurance benefits. You can remind them that Ohio is not a right to work state. The union can negotiate a contract, it always does, that requires an employee to join a union to pay dues or agency fees or lose your job for refusing to do so. A lot of people don't appreciate that. You can tell them that union dues are often 2.5 times an employee's hourly wage per month. I've actually got a wheel that does that and will calculate it for you. You can say the union owns the grievance and can refuse to represent you under certain circumstances. You can remind them that you may give up some individual rights when they organize a union. Majority is what rules when it comes to unionization. There's been a case that's addressed this. Although an employee can still adjust grievances individually with an employer where a union exists, if they've got their own grievances or issues about working conditions, but the union still must be aware and approve of the outcome. So they can still adjust grievances with the employer individually, but it's going to be subject to the imprimatur of the union. And you can tell the employees they'd be better off without a union. You can say that. You can say that you don't want a union. That's your right. That's what HC allows you to do. And you can certainly tell them to vote no for the union on election day. That's something that's completely lawful. Now let's take a look at some meaty issues here that I think will benefit you. Union organization, legal flashpoints. No time to waste for research. When I mentor young lawyers, I tell them, there are certain aspects of the law that you really got to know or have some strong instincts. So when an employer calls you up and says, I got a 50-foot rat at the beginning of my driveway with 20 picketers, with war on worker signs rolling back and forth, what do I do? That's not the time to say, that's an interesting question. Let me get back to you. You better know your stuff. This is a stress area. This is a very important area. So let me walk you through some of the things that you should probably be aware of and have some instincts about. But I'm going to give you 2 caveats here. And this is not an excuse. The labor law is very fluid. It all depends on who's in the office in the White House and who are the board members in Washington, D.C. So the law, as I'm going to present it to you right now, is as it exists right now. And number 2, it's Tom Wiencek's interpretation of the law, which I think is accurate, but I'm going to warn you that I'm a little bit more aggressive in my interpretations and not as conservative as some other labor lawyers. So with that, I still think that these are accurate and worthwhile. So let's talk about the employer property rights, okay? What's your property right for these non-employee union organizers coming on your property? What happens if that happens? You can restrict the non-employee union organizers from your property who are engaging in solicitation or protest, whether that's your parking lots or your public cafeterias. That doesn't prohibit you also from allowing access to your property for charitable, civic, and similar activities. You just can't favor access between unions. So you can't let the Teamsters that come on your property and say the UAW can't be here. But you risk losing protection if you allow non-employer business-related entities. I've used Amway salespeople to conduct business on your property, as opposed to a uniform supplier. So if you've got people who are supplying uniforms, shoes, and other things that are related to the job, that's not going to set an example where the union has a right to be on your property because you're letting other people who are engaging in sales come on your property. So that is okay. And you can, once they are organized, once a union organizes you, they still don't have an absolute right to come on your property. You can require them if they're going to have access to your property to first get permission from HR. You can require them to schedule the meeting before they come. There's always a balancing process once they're organized. They don't have an absolute right to come on your property anytime they wish. What about contractors, employees? What if you got contractors working on your property? You got a bunch of union plumbers that are doing some work. You got a non-union workforce, and they're trying to talk to your employees about unionization. Well, the contractor's employees will have similar rights to regular employees if they work regularly and exclusively on the property, but they can be restricted if they're off duty, if the activity significantly interferes with the use of the employer's property and for legitimate business reasons. So you can restrict them more if it's just a one-off where somebody's trying to fix a pipe and wants to solicit. You can restrict that much more than you can if a contractor is just a normal part. If you're contracting, say, maintenance, and your contractor's employees are really just part of the workforce, then they have the same kind of rights and responsibilities as any other employee. And there's a difference between conversation and solicitation. It's not unlawful for two employees working side by side together to talk about unionization if it's not interfering with their work. Now, there may be some exceptions if they're talking in front of patients or other kinds of residents. They shouldn't be doing that on the shop floor in front of patients or residents. But if they're normally doing something like that and it's not interfering, if it's not an organized meeting, it's just two people talking, that's conversation. Solicitation is when one employee is asking another for a commitment. Joe, I want you to sign this union authorization card, and I want you to go to this meeting at 7 o'clock tonight because we're going to be voting on whether or not we want a union. That's solicitation. That can be restricted on work time and allowed only on non-work time. So solicitation is different than a conversation. Let's talk about a dress code. This is a very frustrating issue for me. The dress code versus the employee's right to wear union buttons on work time. It's aggravating for me. So the employer interference under the current law, it's presumptively unlawful to limit that unless special circumstances can be established to justify the interference. Now, hospitals have been given a little bit greater latitude in patient care areas. So the special circumstances that can justify an employer's restrictions on, say, union insignia, buttons, and pins is number one, if it jeopardizes employee safety, if it damages machinery or products, if it exacerbates employee dissension, whatever that is, if it unreasonably interferes with the public image that the employer has established, or if it's necessary to maintain decorum and discipline among employees. Those are the standards that you can use. Now, obviously, those are kind of vague standards, so it's going to be difficult to defend them. But for the most part, it's presumptively unlawful unless you've got specific circumstances to prohibit it. However, a federal appellate court did say there's much greater latitude to keep a prescribed issued uniform as a uniform. So if you provide your employees with a complete uniform with your logo, they take that shirt off and put a UAW, eat the rich, that I think can be lawfully prohibited if it's part of the entire uniform. But still, buttons and stickers are probably going to be kosher. This is one area that changes a lot, and it's an area that you should consult counsel about if you want to start controlling it. If suddenly people are starting to wear stickers and buttons. Bulletin boards is another flashpoint. Okay, you own the property, so you can restrict the use of bulletin boards for non-work activities such as union organization, as long as you don't discriminate in favor of allowing it to use for other non-work purposes. So if you're allowing solicitations for purchases of items or services or personal occasions or other kinds of non-work communication, you're going to undermine your ability to say that the union people or employees can't communicate with each other about union meetings, etc. So the employee's right to demand to use emails or internal employee mailboxes, a big issue. Currently, there's no inherent right, and I say currently, there's no inherent right to use employer email for non-business purposes as long as you don't allow it for other similar non-business purposes, or proof that employees would be deprived of other reasonable means of communication. However, the old GC wanted to overturn Caesars Entertainment and return to what's called purple communications that allows employees more liberal access to the email systems. So there may be a return to purple communications because it's such an integral part of communicating between employees. But right now, there is no inherent right to use the internal mailboxes and the software, the email software for union activity. Now, creating a rule prohibiting the use of emails in response to an organizing campaign would be unlawful. So if you've allowed, a reasonable use of the email, and all of a sudden the union files a petition and now it's prohibited, that would be unlawful. That would get you an overturn or even a bargaining order. So in practicality, emails are difficult to police. The juice may not necessarily be worth the squeeze, and it would provide a union example why a union is necessary if you're overzealous. But here's the bottom line to keep in mind. You own the property, and how you allow it to be used for non-business purposes is going to control your right to impose restrictions. But the bottom line is you own the property. It's just how you allow it to be used that's going to give you some leverage as to whether or not it can be used by employees for this organizational activity. And frankly, if the union has other kinds of outlets like social media, like emails and other kinds of things where they can communicate with their potential bargaining unit members, that's going to be helpful. But at the end of the day, you own the property. It's just a matter of how you're policing it and what you use it for. All right, Scabby the Rat. I've gotten injunctions against old Scabby. What happens when the Scabby shows up at the beginning of your driveway? Well, it's lawful if it's on public property, but not necessarily on the employer's private property. Now, the Supreme Court, this Glacier Northwest is a very good case because there's a doctrine called Garmin preemption, which says that courts really shouldn't be messing around in union kinds of issues that deal with this kind of stuff. If it arises out of a union activity, an unfair labor practice, et cetera, then Garmin preemption said this is exclusively something that should be done with the board. You shouldn't be running it to federal or state court looking for injunctions to prevent it. Glacier Northwest is a good case. Mark that one down that says, no, not necessarily. There are certain areas of the law that the NLRB doesn't necessarily have the right to impose a remedy. Defamation, trespass, those are the kinds of things that I use when I go in, and I've gotten injunctions against Scabby the Rat. You're always going to, when you're going to and ask for an injunction against this, you're always going to get hit what's called Norris LaGuardia. Norris LaGuardia says that courts should not be putting their nose into union business and granting injunctions. That's something that the NLRB should be taking care of. But Glacier Northwest is a very good case to have in your pocket to say, no, some things are purely local. And that's how you describe it, especially if you're representing a large employer in the county, where they know that there could be some ramifications and you can use the politics on your side. But Glacier Northwest underscores what I've always underscored, that somebody on your property or in front of your property, that's not necessarily just a union issue. That's a property issue, that's a trespass issue, that's a defamation issue, and look at your local ordinance. It's against the local ordinances that you can't have something like that without a license. It's an advertising issue. So there's ways to deal with that. All right, what about publicly criticizing the employer's business and culture in the traditional media or on social media? The cases seem to say that there's a difference between criticizing working conditions, which is lawful. Like the employer doesn't pay, the prevailing wage, versus the employer's reputation and its product, that the service is substandard, okay? The cars are junk. They fall apart all the time. So the focus is about interference with the customer relationship. And these 4 bullet points are what are used to determine whether or not the union or the employees have crossed the line, whether it causes serious damage to the employer-employee relationship, it damages the employer's interests, it's incompatible with the employee's duty as an employee, or it's disloyal, reckless, or maliciously untrue. Those are the standards that you can apply when somebody's taking you on social media. The only exception is if it's for a union representative testifying in front of a government committee, that the cars are simply not safe, et cetera, questioning the product or the service. If it's a union representative testifying before a government committee, that would be protected. But if it's just rank and file employees trying to badmouth the employer's product and service on social media, that is fair game unless it relates to wages, hours, and terms and conditions of employment. So it's lawful to respond to the propaganda as long as there's no threats of reprisals are stated. What about billboard trucks? I had billboard trucks with the CEO's picture on it. Greed, greed, greed. Leadership methods of critical leadership. The billboard trucks will be subject to the defamation standard, especially if the communication does not say it's part of a labor dispute to gain protection. I actually got an injunction against a billboard truck because it didn't say it was a labor dispute to gain the protection. I just said, this is personal, it's defamatory, and I got an injunction against that. So that's where the union can protect itself if they say it's part of a labor dispute. And they can't use the U.S. postal mailboxes in the neighborhoods to criticize the employer or executive leadership, okay? Unless it's got a stamp on it. If they want to do a letter, that's one thing. But if they're putting flyers in that, that's not what the U.S. Post Office, the mailbox is for. And I've told my neighbors, when these teenagers play hockey with your mailbox, you can tell them that, they're dealing with some kind of federal laws here that could be a problem. It's a violation of federal law, and you can check your local ordinances. Once again, in Cincinnati, it prohibited people from putting flyers on in people's doors without their permission. It's unlawful for employee license plates numbers to gather for unions to use the license plates numbers to gather home addresses for personal solicitation visits. And you can also lawfully prohibit customized signature blocks. So if you've got your own customized signature blocks on your stationery, you just can't, the union can't put, Vote Teamster on it or put anything with the Teamster logos on it. Now just think about this. Think about these issues. License plates numbers, customized signature. These are all the kinds of issues that come from real life situations where unions are just trying to exploit and gain access and gain power over your company's culture. That's why you don't want a union, because you get into these kinds of disputes. And my advice to you, you're right to discipline or terminate an employee union activist who's been actively organizing your company. You better be careful about that. I recommend Just Cause Plus. You're going to have to give them a pass on that because the board will scrutinize that very closely. If you want to buy yourself an unfair labor practice or get your election overturned that you won, that would be the one, or a bargaining order. That would be the one. The termination of some union loyalists who are active in the union campaign. All right, let's just take a brief moment about some other union tactics. A corporate campaign, if you're subject to a corporate campaign, you'll know it. It's an organized assault that's directed to tarnish the reputation of the target employer until it yields whatever the issue in the dispute might be. You'll know that. They go to the newspaper, they go to the flyers, they go to the TV. So you'll know if it's a corporate campaign. Salting is what's more subtle. That's a union organizer who hides his union affiliation while he's attempting to gain employment. And once again, the unions tend to use these employee referral agencies to hide these salts. So how do you know if you're being salted? During the process, a salt typically will openly inform you of his union activity. He'll be wearing a union hat, say his current job is a union organizer, and he'll openly state that he's an organizer while you're interviewing. So what do? You remind him that you respect the right of employees to join or not to join. His activity will not be considered to determine if he's selected for the position, or you can simply ignore the statement and continue. But don't deviate from your hiring practices and policies when you're dealing with salts, because the NLRB is going to compare how you process the SALTS application to other candidates. So what's on the horizon? Well, this PRO Act that I told you about that the proposed Secretary of Labor was the only Republican to authorize. It would eliminate the right to work laws, encourage card check certification, which is demand for recognition based on majority status, impose first contract arbitration. So if it's a first contract and you can't get a contract within a certain period of time, it goes to binding arbitration like the public sector. It would legalize secondary boycotts against your suppliers and other kinds of related entities, and make it more difficult to establish an independent contractor status versus an employee relationship, and make it easier for corporate entities to be joint employers. This is a wish list of the union, and it concerns me that the Secretary of Labor voted for it. I don't know what's going to happen in the Trump administration. Preferably it goes to die a death. So what are the 10 commandments of union organization prevention? Once again, knowledge is power. Know your legal rights. It reduces your anxiety and bad decisions. It prevents exploitation of your judgment that makes you less assertive of your rights. Kill them with competence. I always say that. Be great at your job. Be responsive. Be admired. Keep up with the legal trend. Join HR associations. Read the periodicals. If you can afford it, subscribe to the daily labor report, but it's expensive. It's a couple $1,000 a year. Be aware of the competition, what people are paying, so that you know where you are in line. Know your workforce and the influencers. The old adage, keep your friends close, but your enemies closer. Keep an eye on them and engage them. Absolutely control the narrative of your culture and be an excellent example of it. And be aware of your interactions with employees. You can win the argument, but you can lose the relationship. It's like any other relationship or marriage. Cut the employees some slack sometimes. And obviously, recognize and reward performance and excellence. Create and provide opportunities for growth and advancement. And create an environment where people matter, where they're not just considered another cog in the wheel. And last but not least, don't be afraid to throw a punch. I did this when the SEIU was negotiating with us and trying to leverage us. They had those billboard trucks running all over Cincinnati and flyers and all that. And then they said that they were going to have some mass picketing. So what I did is on both sides of this driveway for this hospital system, we put shame on the union. That blew their minds. Not many labor lawyers would do this, but it undermined their picketing activity. And the public actually thought that the protest was against the union. So don't be afraid to throw a punch, because the unions, all they know is power. If you can answer them with some power and they know that you know what you're talking about, that's intimidating, that you're not an easy mark. And of course, what can Roetzel do for you? We've got supervisor training. We can look at policies and updates, inform you of your legal rights. We've got forensic computer analysis, workforce analysis, culture control, corporate campaign defense strategy, information on union activity. We've got updates and trends, union-free campaigns and election campaigns. I can get you up and running in less than 24 hours. I've got a binder that covers every step of the organization process. When my college classmate called me at 5 o'clock on a Sunday night and says, we've got organization activity up here in Detroit City, I was up there in less than 12 hours with a complete plan and how to address this, so we can hit the ground running quickly. The representation before the NLRB and the newsletter updates, which I think are important to keep up on the various trends. All right, and that's me. That's the end of it. Victoria, do we have some questions? One of the questions that was presented before the presentation was, what are some of the typical things that you can do to generate an unfair labor practice? Well, let me tell you this. This is how liberal some of these administrative law judges are. We won a Teamster election by a 2-to-1 margin. And at the time, the captive audience speech was allowed. And the president said to the employees that in 2020 we were short-staffed because of because of COVID. And I subcontracted a part of my business out and found out that I could do it a lot more cheaply. But even though I could do it more cheaply, I brought the business back in because I wanted to control it here and I wanted to make sure that you guys did the business. The administrative law judge viewed that as coercive and overturned the election, even though we won by 2-1. Thankfully, we appealed to the regional director and she overturned that and certified the election. And now you get to appeal that to the board. So that'll just show you that depending on the region that you're in, depending on the administrative law judge that you're before, you always take a risk. But certainly if you're terminating people who are active in the union organization campaign, that's going to buy you an unfair labor practice and maybe even a bargaining order. If you're giving wages and benefits that you've never given before, except for the union coming in, that's going to bonuses and things like that you've never given before, that's going to be raising a red flag. If, like, and I had a situation where we always gave certain performance bonuses every January, and it just so happened that the union filed its petition for election in January, and we continued with the bonus. That was fair game. They made an objection to it. They said it was based on the union's activity, but the board rejected it because we demonstrated that for the last 20 years, this is the kind of pattern that we do. This is what we do. We take a look at the performance of year end in December, and then we decide the bonuses in January. We didn't deviate from the process. So that's what you're going to have to demonstrate. If you already have pre-existing wage increases, pre-existing benefit adjustments, pre-existing bonuses based on performance, you'll just have to demonstrate that that's what happens all the time. Okay, there's no open questions. So we're done a little bit early. I really and truly enjoyed presenting this. I hope you've given some insight. And I can tell you that Roetzel has a very strong labor and litigation department. We will be glad to be of service. So keep us in mind if you have any kinds of labor relations issues. Goodbye and be well.
And Tom, we did have a question that just popped in the Q&A.
Okay. What were the sources for the labor contracts? That's in the slide that I can send you if you want to send me your email. The labor contracts are from the Department of Labor. There's a certain section of that and the Cornell University. So if you want to, it's TWIENCEK at ralaw.com. That's TWIENCEK at ralaw.com. And I'll send it to you. Okay, be well, everybody.